As president of the European Law Institute, it is my pleasure and my honor to greet you all to celebrate the newly instated ELI Members' Day. This ELI Members' Day will be celebrated each year from now on in a sense of staying close together and acknowledging some important achievements. The event is both backward and forward-looking. Backward-looking first, Lord Thomas, first Vice President of the ELI, will speak briefly on ELI's establishment, its achievements and impact. Backward-looking also with a book. Indeed, we have produced a book to commemorate ELI's anniversary and to acknowledge the commitment of its founding members, others that patronized ELI from its very foundation, which means members of 12 or more years, as well as those that pay over and beyond the basic ELI membership fees, sustaining members in support of ELI's causes. Backward-looking, finally, in that founding and enduring members have also been sent certificates acknowledging their dedication and support over the years. The idea is then to acknowledge further generations of members in the years to come. And then we will be forward-looking. You will get more about this by Teresa Rodriguez de las Heras Valer, member of the Executive Committee and chair of the Membership Committee. Finally, but this will be in the second part of this webinar, we will also be forward-looking with a section on law in the Metaverse. I will tell you more in a couple of minutes. So stay with us for this wonderful evening of celebrations and reflections on forward-looking issues. It is now my pleasure to give the floor to Lord John Thomas. He served as Lord Chief Justice of England and Wales from 2013 to 17 and was president of the European Networks of Councils for the Judiciary from 2008 to 10. He's president of the Qatar International Court, a practicing arbitrator, chairman of the London Financial Markets Law Committee, and sits in the UK Parliament as a member of the House of Lords. He is Chancellor of Aberystwyth University and is an honorary fellow of Trinity Hall, Cambridge. He is also our current first vice president. He will address you with some words on ELI's establishment, its achievements and impact, and he's also an ELI founder. That's why he's very well placed to speak about it. John, you have the floor.
It is a great pleasure and privilege of me to say a little bit tonight. I know I'm going to be looking backwards, but actually it's to strengthen our forward-looking vision. It was when I was president of the European Networks of the Council of Judges, I came together with others in deciding we really did need to bring together the various different interests in law in Europe. And we took as our model the American Law Institute. This year, although we're celebrating only 12 years, the American Law Institute has celebrated 100 years. And it was founded to try and ensure the survival of a common law system, because given the United States had by then 50 different states, the number of cases being decided threatened to overwhelm the common law system. And we took our model from that, but with a very different perspective. And that was to try and ensure that in a new and developing Europe, we developed the law according to new ideas, new projects, and also, I think, trying to be much more of a think tank than maybe other institutions have done. But the American Law Institute was critical to our way of looking at things because it puts the members at the heart of its work. It's constructed in a way very similar to us because we model ourselves on it. And I think that when we look to the achievements, what is critical is the strength of our membership. And in that respect, it's the three constituent parts of the Institute that are so important. The academics who have all the ideas, who have I think I may say, though, this respect to Pascal and Teresa, they have the time, though they both seem to conjure time out of fresh air. And they have the willingness and determination to act as the rapporteurs, to do much of the heavy lifting. But you can't develop law without the involvement of people who are judges and people who practice day to day. And it's academics who are members, it's judges who are members, and it's practitioners who are members who give the Institute its strength. And we look to them to help in every respect. Now, what have we done so far? I think there are 4 questions we ought to ask in answering the question, has ELI delivered over the last 12 years? Well, I think the 4 topics I can take. First of all, what's the range of our projects? I think it's been incredibly diverse. If you group them under the 3 headings of rule of law and convergence of systems, we've done freedom of expression, for example, tax, succession law. If you look at the digital age, then one can look at blockchain, smart contracts, algorithmic decision-making and the like, and sustainable life and society. For example, access to justice and effective remedies and ecocide. The range is enormous. Now, what about the quality? Well, I think it would be, I'm not an impartial judge in this respect, but we have taken steps to ensure that there is an objective judgment of quality. And I think that we have really brought forth work that is of high quality. And how do I say that? Because the acid test of this is impact. And many of our projects have given rise to stimulating the development of law, policy, and practice. And I think we can point, I would like to take as an example, and these are but examples, 5 things. First, to be really up to date, yesterday, the Commission announced its proposal to put forward a regulation relating to the protection of adults in cross-border cases where the adults needed protection, for example, where they had impairment of their abilities. And it was pleasing to note that was based on a seminal report of ELI in 2020. The second area to look at is in something much more to the heart of lawyers, procedural rules. And the model procedural rules that we did with UNIDROIT have really been important. They've interested the Commission and 2 committees of the European Parliament. Jury, for example, was influenced in its stance for the need of common minimum standards of civil procedure. And then something more exciting, which has really been looking at the digital economy and the principles for the data economy, in which Christian Venderhorst played such a leading role, has proved influential worldwide. One sees this in the view that's been taken of it in China, the view that has been taken it by the Commission, and its importance in UNCITRAL. And then something, again, an example of how diverse we are, the rescue of business in insolvency, a very, very important topic. Possibly it becomes more important as the economies get into difficulties. And what we have done there has been used not only in the restructuring directives, but have been used by national courts. And then finally, my 5th example are the principles for the COVID-19 crisis, which were developed at quite considerable speed at the outset of the crisis. And there, for example, they were cited by an advocate general at the CJEU. Now, I think if one takes that objective standard, I think we can say we've delivered. Now, how's this been done? That's really my address to you all as members. It's the members that are key to this. And I very much hope that we will continue to see broad participation in putting forward ideas, but most importantly, as is done in the American Law Institute, through the members' consultative committees. You may feel, as many people in democracies feel, that they have no influence on what happens in the development of the law. But I can assure you that if you engage with ELI through the membership consultative committees which exist in all our projects, you can put yourself down as having participated in and furthered the achievement of what is important work for the law in Europe. So looking to the future, I think we've built a sound structure. It seems to me that there are a huge number of ideas. You only have to look at what we're doing. But what is critical is the membership, the three components of the membership, the academics, the judges, and we definitely need more of those, and practitioners. So please give us the support. I'm not now telling you this from a point of there being no achievement. The achievement has been substantial. Thank you all very much.
Thank you very much, Lord Thomas. Thank you, John, for these words. And you said the members are central, and that's why we have now this ELI Members Day concept that will be presented by Teresa Rodriguez de las Heras Valel. She's Associate Professor of Commercial Law at University Carlos III of Madrid. She's currently an academic visitor at University of Cambridge. She is a delegate of Spain at UNCITRAL, Working Group 6 and 4, expert for UNCITRAL and UNIDROIT on digital economy projects, arbitrator at the Spanish Court of Arbitration, and member of different EU expert groups, among others, on liability and new technology. And she is also a member of the ELI executive and chair of the ELI's membership committee. And it is in that last position, if I may say so, that Teresa Rodriguez de las Heras Valel will present us the ELI Members Day concept. Teresa, you have the floor.
Thank you very much, Pascal, and thank you very much for those of you who are joining us today, because it's indeed a very exciting time, a very exciting moment. It's very rewarding, and I have to say that as the chair of the membership committee is a source of pride, because that has been indeed one of the various proposals that the membership committee has put forward in order to achieve what we consider is one of the most important value of ELI as a community. That means that all the members contribute to the future of the ELI work. And that is precisely the idea of this Members Day, ELI Members Day. We also have other channels. Through them, you can, using the suggestion box, for example, to propose some project. There are many other possibilities for you as members to propose emerging topics. But today, we wanted to create this space, these opportunities for all members to bring about, to propose, to contribute with emerging topic that ELI should look at and may embark on in the future. This is the idea of selecting today a topic in order to materialize where we want to be in the future year, the Members Day. And the topic that we have selected has been the law of the metaverse. We have been approached by several organizations expressing the interest in the law of metaverse. And the law of the metaverse indeed is very much interconnected with other projects that the ELI has already approved or is working at the moment. And this is incredibly fascinating because the law of the metaverse might be indeed an evolution of the law of the digital economy. So we have many questions that we have to raise. Do we already have in the new growing regulatory scene that is governing the digital economy, the platform economy, the data economy, the use of artificial intelligence and automation in the digital economy, are all these instruments the building blocks of a law of the metaverse? Or is indeed the metaverse raising and posing new challenges that required a different way of solving problems, a different way of protecting interest in the metaverse? So indeed, we have a fascinating discussion in front of us. We have to use what we have already done in the ELI in order to understand to which extent all these contributions have already indeed paved the path to the idea of what is the law of metaverse. We're going to have a session, as Pascal has already presented at the beginning of this webinar, that is going to be devoted precisely to exploring and discussing and pondering the different interests that have to be taken into account in this proposal that might become a project for the ELI. The idea and the decision to create a high-level expert group in order to consider and explore the opportunity and the possibility of starting a new project is going to be indeed decided in our next executive committee meeting that is going to be in a few days, and therefore we will decide afterward how that is going to be, if it is crystallizing in a different project. But the law of the metaverse represent the kind of project that the ELI could indeed approach and address. Why? Because the diversity that Lord Thomas has been describing as the value, as the richness of the ELI community is absolutely fundamental. A diversity in the fields of law, a diversity in the profession, and diversity between institutional members and individual members, a diversity in terms of territoriality and jurisdiction and legal tradition. All these kind of elements are going to be absolutely fundamental in order to approach, address, and tackle the problem of the law of the metaverse. So it's indeed a very, very important moment today. It's particularly exciting for me, and I'm extremely proud that we have this time, this scene, this place for discussion all together. Thank you very much, Pascal.
Thank you very much, Teresa. Indeed, this ELI, first ELI Members Day is also an opportunity to look forward to further projects, and look forward also to further issues. And to do so, we thought it might be very important to have a large panel of different people that I will have the pleasure to present to you why they will be asked to speak. We have asked them to make a very short statement first, so that we will still have a time for questions and answers after everyone has spoken. So you will be during and above all after the presentation, you will be able to ask questions by using the Q&R logo and ask a question linked to their respective statements. I welcome you, therefore, to this second part of our ELA's day, which is, as I say, linked to the metaverse and the law. And the task will not be easy, as first, people do not agree on the proper definition of what the metaverse is. And second, because the metaverse does not exist fully yet for a couple of reasons. So we are speaking about something that is not defined yet, or at least there's no agreed definition. And secondly, that does not exist totally, at least, as we will see. Among many definitions, I will choose the one proposed by Matthew Ball in his 2022 book entitled The Metaverse, where he defined it as, and it's a quite long definition with several parts, a massively scaled and interoperable network of real-time rendered 3D virtual worlds that can be experienced synchronously and persistently by an effectively unlimited number of users with an individual sense of presence and with continuity of data, such as identity, history, entitlements, objects, communications, and payments. You understand now why it takes a book to explain this definition. This immersive three-dimensional virtual world has no physical limitations, but does it have legal limitations? Romans used to say, ubi societas ibi jus, where there is society, there is law. Therefore, there should be law in this post-reality universe, as it has been sometimes described, because many people interact together, and this is society. The potential at stake seems phenomenal, at least if one looks at some figures. Meta has already invested more than $36 billion in the last 3 years, and the estimated market value is many billion US dollars as well. At least that's what one can read in various news. Even if Meta has announced in May 23 some significant losses related to the metaverse strategy, things will continue to be central. Apparently, the sale of real estate in this digital space has increased rapidly, exceeding $500 million already in 2021. But recently, the value of these digital spaces have been reduced by 90%, some say at least quite recently. In 22 and 23, Metaverse was in everyone's mouth. And then came ChatGPT and other deep language learning. The metaverse will remain, it seems to me, a central point of interest in the year to come. Of course, it might be a different type of digital world with even different AI 3D digital reality. The merger between the digital and the non-digital world has already begun. End of May 23, an information stressed that China wanted to become the world leader in AI technology in 2030. For example, in Fuzhou, southeast of China, a technological enterprise called NetDragon is chaired by Tang Yu, a virtual woman created by the employees themselves. Tang Yu has under her command 6,000 employees who therefore have no secret for her. Working times, projects, performances, she knows everything. Similarly, influencers have been dematerialized. Nanjing Silicon Intelligence in Nanjing, east of China, creates hundreds of thousands of virtual influencers every day. Metaverse is therefore a place of interaction in which humans interact with others, but through 2.0 alter egos, if I can say so. This means that there are several levels of interactions, a metaverse-only interaction, a real world, whatever that means, interaction, and a cross-interaction, metaverse, real world, or non-digital world, if you want, for each of these humans and legal entities involved in the metaverse. Of course, it is not just the interaction that is subject of regulation, but also the purely technical level of AI and digital products. From extended reality, XR, to virtual reality, VR, and the ultimate BCI, brain-computer interface, the number of potential issues are growing and will be in these 3D virtual worlds. The synchronous 3D virtual reality implies, however, a capacity for this next internet, both in terms of bandwidth and low latency that are not yet available, but will probably be soon, hopefully. Will there be one metaverse or many? The future of these 3D interoperable worlds is not yet set, but part of these worlds are already operating, and I'm not just speaking of Fortnite or Roblox, but also of others. So we better try to identify today all those various issues. The ELI, and that was mentioned by Teresa already, has already embarked on some of metaverse-related projects. I think of the, of course, project on blockchain and smart contracts concluded in 2021, of course, because payment on the metaverse will be made also through smart contracts and cryptos. The project on a new directive on product liability of 2022, which deals with defective products needed for the metaverse, but also the project on enforcement of digital assets, still ongoing. The one on digital assets as securities will also help to evolve within the metaverse. And not to forget, of course, the ADMS, algorithmic decision-making systems projects, which address the issue of impact assessment of such ADMS used in administrative decision that could be, who knows, used in the metaverse. And of course, the interaction depends also of a number of individual sense of presence, says the definition. And this individual sense of presence will be linked to biometrics, soft, hard biometrics, different aspects that will also be relevant for the metaverse. I'm sure that the ELI will continue to look at some further aspects and projects related to the metaverse. But today, with our panel of experts, we want to tackle some of these various issues. The interaction between the non-digital and the digital world may well impose to be informed that I'm dealing with an AI or a deep AI, that my digital space is or is not related to a non-digital space, or that the one who is speaking to you right now is not a deep fake or maybe a deep interacting chatbot. So I'm sure that our discussion tonight will be fascinating with an exceptional set of speakers. And after this first introduction to the topic, I want to greet with us Cecilia Alvarez. She's the EMEA Privacy Policy Director at Facebook since March 2019, or Meta. From 2015 to 2019, she served as European Privacy Officer lead of Pfizer, vice chair of the EFPAI Data Protection Group, and chairwoman of IPPC Europe. For an interim period, she was also the legal lead of the Spanish Pfizer subsidiaries. She formerly worked 18 years in a reputed Spanish law firm, leading the data protection, IT, and e-commerce areas of practice, as well as the LATAM Data Protection Working Group. Cecilia Alvarez will speak to us today about the benefits of the metaverse, and as Privacy Policy Director of Meta, she is, of course, the best place to do so. This is why it's my pleasure now to hand over to you, Cecilia.
Thank you very much, Pascal, and thank you very much, Teresa, and everyone who has made possible that I am here with you today. So it's not necessarily that I will speak about the benefits per se, but at least with respect to use cases, as Pascal was anticipating, the metaverse is still under construction. And the technologies that are mostly on which the metaverse is based, that is the virtual reality and the augmented reality, that was something also that Pascal mentioned initially, is already there. However, the use cases are as various as the imagination, I think, of human being will give us. Some of them, I think, are already there, and I would love that before we enter into the discussion sur le vif of what is the metaverse and which kind of legislation is the best one that is serving human being purposes. Maybe I would love to share with you some use cases in order that for those, as the case may be, who are less familiar with the metaverse, that enables us to see how broad this kind of use cases could be. It is true that I will not be able, without you wearing glasses, to have this sensation of immersion, because it is not possible through a bidimensional system. But the closest that I probably can give you today are some snaps of these use cases. So I will try to share my screen. Hopefully this is going to work. So let me see if I don't know what can you see? If someone can help me in order to be sure that you are saying something.
Yes, we are. Yeah, we see the law in the metaverse, a slide.
Okay.
From
And
your computer.
Okay, and you see hopefully images that are changing. Okay, so hopefully this is going to work. So let's go here. We have, well, different images that probably is much more important that you are seeing the images rather than what I will tell you, because there is nothing else that having your own impression with respect to elements that you are going to see, either with respect to universes that are completely virtual, in the sense that you are really transported into something that is made in a digital manner, and other kind of universes in which you are going to see the reality and superposed with metaverse element, which is the element that we have with respect to augmented reality. such as some of the images that you are seeing in this table for the children, right? That you have other kind of digital elements that are participating into their real experience as well. So I think the metaverse is enabling you to learn maybe about anything that you have in the world, but bringing it maybe closer to you, or having another kind of interaction of experience with this. Some of the images that you are seeing could be, we can see streets of the ancient Rome, and you can be actually standing there and being able to hearing the sounds, to visit the local market, and to get maybe a sense of what we, through the historical and the research life, we can imagine how life was like over 2000 years ago. At least it gives you another kind of interaction that in the way in which probably all of us have been studying ancient Rome through wonderful books that has enabled us, right, to have an imagination, and through movies also trying to recreate what ancient Rome could be. This doesn't mean that it will replace these wonderful books or, as the case, movies, but it's just another way for you to interact with a recreation of what ancient Rome could be. And for this, there is one that I cannot show you here, but I have experienced that I recommend it very much, which is the Reconstruction de Notre-Dame de Paris, which is the rebuilding of the cathedral, so famously known, I think, for everybody of Paris, in which actually you can experience to be in the cathedral, in places probably in which you as a visitor will never be able to be, but that through the recreation, through the metaverse, you can be standing in places and see how this incredible cathedral is. And there are some of these experiences of the metaverse in which you have been following the story of Notre Dame and following how people were actually building it. And this is something that cannot be probably replaced by other ways in which we have been learning things about this cathedral. We can also visit a virtual planetarium, which is another kind of the visuals that you can see here, with students from all over the world and entering in maybe into a transporter, beaming out to a starship and going on a spacewalk. You can pick up a planet and turn it around in your hands to get an up-close view, and then hand it to your friend who's right next to you in the virtual world, but in the real world actually lives on another continent. You can imagine a health researcher studying heart defects being able to view a 3D image of a human heart. So there are so many examples of just probably a fraction of what we may be able to do in the metaverse. So what is the metaverse? I know that Pascal mentioned that there are so many definitions and not a single one. This happens probably all the time with the metaverse and many other things as well. But well, how we see the metaverse is probably like the successor to the mobile internet, in the kind of a virtual environment that you can be present with people in digital spaces that are interconnected. And it feels like you are being inside the internet instead of being a spectator, instead of looking at it on a computer or mobile device, which is the things that we have been able to do so far. So you have this kind of immersive worlds that you create and you can interact with all of this visual information that includes definitely a position in the 3D space. Your body language, Pascal was mentioning biometrics, not necessarily all the body language information will be biometric, at least if we take the definition of the GDPR, which is not necessarily a definition that will stand forever, I don't know, but at least with respect to the actual concepts, not all body language information is going to be biometric, or your facial gestures that could be mimicked by avatars. In any case, it will be an experience that is first-person perspective, so that your experience and you move it as if you were really there in this virtual work. Let's have another element with respect to immersive learning in particular. I will go now a bit more quicker because there are many other wonderful people that we need to hear from. But let me give you some figures with respect to the studies that have been made regarding this sense of presence from students when they are learning from immersive environments, that apparently they significantly improve comprehensions and recall and retention when we compare this with traditional methods of learning. And in particular, there has been a study from Stanford University and the Technical University in Denmark, which showed that immersive learning through VR has resulted in 76% increase in learning effectiveness over traditional instructional methods. Let me move to another area still related to education. In this case, this has been a real partnership with Prisms, which is run by a former teacher that has built a virtual math and science curriculum for grades between 8 and 12. And this program is teaching high school students math in an immersive manner, using, in this case, virtual reality. And the curriculum helps students to learn math concepts through 3D movement and visualization, and includes modules from algebra and geometry. So this is one way in which these metaverse environments could actually be applied. I do not leave education because this is something that I personally appreciate particularly. This is another kind of partnership, in this case, that has been created by the NASA in an attempt to improve physical model simulation of spacecraft in 2010. And this was a first definition of a digital twin. But now this kind of digital twin that the NASA experimented in 2010 actually are used in many industries, including manufacturing, real estate, construction, and education. The one that I chose is a partnership with Victory XR to build digital twins on 10 university and college campuses. And you have these metaverse cities that are replicas of existing campuses in full spatial 3D at colleges and universities across, in this case, the US. And in these virtual campuses, students are able to move about and socialize and learn and compete in activities and take part in classes they can access remotely. So this enables you to have a kind of maybe Harvard experience without having the cost of paying. Of course, you are going to lose if you are not there physically, other kind of things, but it's not, again, a kind of replacement, but another way for you to participate, in this case, in a education experience. Let's move to another kind of use case, this time not in the education space, but kind of, because it's training for healthcare professionals. In this case, I am referring to another partnership with the Children's Hospital of Los Angeles, that they wanted to build a VR simulation that places medical students and staff in rare but high-risk pediatric trauma situations where split-second decisions determine whether a patient lives or dies. And through this power of VR, we can replicate training scenarios in a true-to-life fashion, which enables to facilitate the training for healthcare professionals regarding cases that are very rare, and therefore probably they are not going to be trained just by life experience, but something that when it happens, you really need to understand and to act quite quickly. Keeping the medical environment up, we have another kind of medical training using also metaverse capabilities. In this case, is partnered with the World Health Organization Academy with respect to AI courses that teaches healthcare workers how to safely take on and take off personal protective equipment. That was something that, as we knew, unfortunately, was so urgently needed during the COVID-19 pandemic and beyond. Working trainers, this is another kind of use case with respect to having VR that is enabling a cost-effective way to scale training and to improve performance and increase retention of new skills. This is something that has been used by Walmart since 2017, training workforce in VR in order to enable, and some figures also for you, that it enabled to improve the employee retention of new information by 10 to 15% compared to the typical combination of videos and online demos as classroom work. And let me go to the last one that is very, very different to the other use cases that I mentioned, which is advocacy. In this case, this is the United Nations that have a program named United Nations Virtual Reality Series that produce a VR film called Clouds Over Sidra. And in this case, you have viewers experience from the Zatari refugee camp through the eyes of a 12-year-old girl named Sidra, who takes you to visit the camp where she and her family lived after fleeing Syria. So you follow her from her family tent to school and football pitch in the camp. She leads you through her daily life. And this film was created by the United Nations in order to raise awareness of the Syrian refugee crisis and to influence the public opinion and being able to raise funds. And actually, they raised almost $4 billion in this respect. So I pause here, but just wanted you to have like a flavor of things that are already there, that do not end the possibilities of use cases of the metaverse, but it's definitely something more than gaming. That probably is the first thing that many people have in their mind, and that of course also includes gaming, of course, but it's definitely not ending there. Thank you.
Thank you very much, Cecilia. I said it will be interesting tonight, and it is indeed. You gave us a flavor. If we would be in the metaverse, of course, we would sense the flavor. And now we are only two-dimensional. So we are looking forward, of course, to these different use cases. Now, you mentioned architecture, and we have with us Helmut Kitzler, Associate Director of Zaha Hadid Architects, who will speak about architecture in the metaverse. Helmut Kitzler is director and head of VR, has been with Zaha Hadid Architects since 1998. Since then, he has worked on a number of important architectural projects, such as the Phänoscience Center in Wolfsburg, Germany. Besides his work as a designer and project director, Helmut is an avid gamer and closely follows developments in the gaming industry. In 2014, he started the Zaha Architects VR group with the aim to develop the technology for applications in the practices design and presentation workflow and develop a comprehensive understanding of emerging cybernetic space and culture. So for us, it will be really interesting now to have his point of view on metaverse, the law, and the need of architecture in the metaverse. Helmut, you have the floor.
Thank you very much, Pascal, for the introduction and also for the invitation to this amazing event, which in a way proves to us that despite the little waning hype of last year and beginning of this year, that the metaverse is experiencing a serious evaluation. And I think we're kind of convinced that it will become eventually a reality, despite knowing that there is still a lot of work to be done. I have initially thought I wouldn't show any images, but Cecilia obviously almost forces me to show you a little bit, because we are ultimately designers, as you said, Pascal. So let me quickly share you at least sort of a little snippet of our work. I hope this is now visible. This is a sketch of a multiple world metaverse construct for a topical world that would be centered around art and culture, that we were in discussions with a potential client. Just to give you a flavor, so these would be big, large open spaces that users from around the globe could log into and experience and trade and connect and discuss and socialize, but also obviously use these spaces for commercial transactions. So that as a backdrop to my little talk that I prepared, which is completely, utterly void of space and design as such. What we would like to do is join you today in furthering our collective aim. And this is pretty much our conclusion to this initial effort of creating the metaverse, that it is a highly collaborative effort. We will have to reach out way beyond our comfort zones and disciplines to create this multi-stack technological phenomenon that Pascal was talking about. What we're aiming for is clearly an open, human-centric, trustworthy and inclusive metaverse. That is also a direct translation, I think, from our traditional architectural mission statement. As architectural space makers, we are clearly interested in commercializing and offering our services in this emerging domain. And we are committed to safeguarding and enhancing the immersed individual's experience and perspectives. One crucial aspect of our work and research was identifying intellectual property rights for our own sake and services and governance models that support human-centric vision of our metaverse. that we want to create. Through our in-depth analysis in the Horizon 2020 project, where we called Prism Arc, we have uncovered extensive bottlenecks and miscommunications in the current architecture, engineering, and construction industry. These challenges arise from the lack of a unified, collective, and immersive information space. What we have done in this project ultimately is taking stock and forensics in our current workflows that would ultimately enable us to enter into this digital domain, into this virtual space. What we identified is that a convergence of multiple diverse perspectives into a realistic multiple point of view MPOV environments is needed, as well as software and platform interoperability, IPR management, persistence and traceability of authored data and actions for real and virtual world accountability. So this is also where we are departing from a gaming scenario, clearly. And this obviously adds tremendously to the performance and the governance aspects of these worlds. Our research emphasizes the importance of adapting high fidelity simulation and open source interoperability models to enable efficient and effective communication within the metaverse. In addition to addressing industry-specific challenges, we understand the broader implications of the metaverse and its potential to revolutionize various domains. Our expertise as space makers and our advanced research into virtual reality have highlighted the centrality of the embodied human experience in future metaverse constructs encompassing embodied human perception and interaction. By leveraging immersive technologies, we can simulate social and cultural processes in the metaverse, transcending the limitations of algorithmic modeling, costly real-world experiments. And these social cultural processes, constructed and reconstructed dynamically in virtual space, retain the complexity and malleability. As a result, the metaverse becomes a series of interlinked cultural and social and architectural experiments that inform decisions in the physical world and spanning industries, logistics, culture, society, and the built environment. Immersive virtual reality provides a unique opportunity to address complex questions at all levels. To do so, we emphasize the importance of human-centered data, ensuring the usefulness and completeness and regularity of available data sets. We firmly believe that data is a collective resource contributing to a fairer economy and shape healthier environments in distribution of these data sets. Our aim is to make shared data sets widely accessible, encouraging engagement and fostering a shared understanding of real-world problems and proposed solutions within the metaverse. However, for emerging technologies to thrive, they must operate within existing socio-cultural, political, and economic frameworks. We acknowledge the need for technological innovation into the discourse to facilitate the evolution while considering compatibility with established systems. And I think this is also our point of discussion, where we are looking at integrating in legal structures and thoughts and ideas that need to connect into the physical world in our traditions and cultures and societies globally. Privacy and security are critical factors in ensuring the viability and adoption of immersive technologies. It is our responsibility to protect the privacy, identity, and data of all participants in the metaverse, authors and users alike. Adherence to European and international legal frameworks and collaboration with existing efforts in privacy and security are vital to create a safe and trustworthy environment. By incorporating these considerations into our collective efforts, we can contribute to the development of an open, human-centric, trustworthy, and inclusive metaverse. Our work extends beyond the physical realm, embracing the potential of virtual spaces to empower individuals and fostering meaningful connections. Through projects like Prism Arc, we explore the fusion of architectural principles and technological innovation, blurring the lines between physical and digital realms that we wish to become worlds that stimulate the senses, evoke emotions, and facilitate meaningful connections. So in conclusion, our collaborative endeavors, guided by a holistic and unifying human-centered vision, are geared towards realizing the full potential of the metaverse. We strive to create a metaverse that transcends the limitations of current industrial processes, embracing the transformative power of digital collective space. And we would like to work together with you to shape a metaverse that reflects our values, aspirations, and safeguards the well-being of all of our participants. Thank you.
Thank you very much, Helmut. Also from this perspective, from an architect, when we are discussing these legal issues, it's really interesting. You mentioned human-centered data, you mentioned data as a collective resource, but at the same time, you mentioned IP. And of course, this is very central. And that's why we are very grateful to continue our panelists, our tour de table, our round table of panelists with Professor Jacques de Vera from the University of Geneva in Switzerland. He's a full professor of the law of obligations and of intellectual property, dealing a lot with digital law and IP. He's the director of the Digital Law Center in Geneva and also a member of the MITS committee. And he was also visiting professor at various leading universities abroad, including Harvard, Stanford, and others, including Paris, just to refer to Cecilia's mentioning the cathedral. So it's my pleasure now to give the floor to Jacques de Vera, on IP law in the metaverse for your couple of thoughts, Jacques.
Thank you very much, Pascal, and thanks very much to the European Law Institute for this privileged opportunity to be on the panel tonight, and thanks to all the participants who are joining us. I know our time is very limited, and as a Swiss citizen, I'm well aware of at least the temptation and the attempt to try to keep the time limits. I still wanted to share my screen, and hopefully that's going to work with the other, as for the other panelists. Unfortunately, I don't have many images to show because this is more boring legal stuff, but I still thought that it could be relevant to take a step back because obviously it would not be possible to cover the many facets of IP law which may arise in the metaverse, but perhaps to take a meta view and see if I can just move to the next slide, what we can do. But before doing so, I perhaps was thinking that, Cecilia, you would mention that at some point there was perhaps an interest to shift, but actually I don't think this is a shift based on what we could see. And actually even moving from the metaverse to AI, it seems that the two can be combined. So also to congratulate the organizers for choosing that topic, which makes it possible, and this is basically what I wanted to do, to perhaps illustrate and focus on four what I've called meta principles, which could govern like new meta IP laws, which actually are not that new to the extent that they can illustrate how IP law may need to evolve in the digital and online environment. And what I want to do in the few minutes that I have now is basically go through these four principles. And of course, I'll be happy to share my slides if interest, and understand anyway that the event is recorded if of interest. The first one is actually to really keep in mind that even if we talk about IP, perhaps IP should not be the real focus. And the reason is that the online environment, the digital environment, is governed by contracts. And if we come back to this quite famous title of this op-ed, which was published by this very established venture capitalist a bit more than 10 years ago in the Wall Street Journal, writing, as you can read, why software is in words, we may wonder to what extent we could reuse and adapt the title and refer to the contracts which basically govern the metaverse and govern many of our online activities. And these contracts are these EULA and user license agreements. And I think if we don't take that into account, I'm afraid that we may miss the point to some extent. And I think what we would need to do from an IP perspective is to look very carefully at how the IP provisions in the allocation of rights, what rights are reserved for users of this metaverse and other environments, and how we can keep a balance of rights between the respective stakeholders. Because of course, it's great to have in the IP laws certain provisions which would allocate the rights in a certain way. If in any event, this is somehow challenged and made unapplicable in a way or another by contractual provision, I think this is something that should be taken into account in the first place. The second point is, and that is perhaps a good news to some extent, is when we think about IP regulation, we should have a broad perspective. And what I mean by that is that we shouldn't underestimate the power of soft law. And I think we have many examples in the digital environment, and specifically, I would tend to think in the metaverse environment, where soft law works. And actually, soft law is the only way forward. And even if we look at the IP ecosystem, we have one document, which is the one that you have on the screen, which is pretty old because it goes back to 2001. So in the prehistoric age of the internet and the digital world, which is basically, as you can read, a recommendation. So it's certainly not binding, but if you see what has happened with that document is that it offered extremely valuable guidelines and guidance to courts, to regulators all over the world. So I think it's encouraging to see that when we talk about IP regulation in the online environment and specifically IP regulation for the metaverse, we should also rely on soft law, meaning that all stakeholders should come together and play a role, and potentially, of course, ELI. And we see that also happening, and of course, I follow very closely what's happening here in Geneva at WIPO. As you may know, or some of you may know, WIPO has launched these so-called WIPO conversations, one of which, and this is what you have on the screen, focused on metaverse. It was back in March. And what's interesting is that the ambition here is certainly not to come up with an international treaty. It's not even to come with like binding guideline whatsoever. Is just to have a discussion, and discussion is the first step towards potentially future regulation. I think it's quite important to keep that in mind and to move away from like classical regulatory approaches, which would necessarily and have to lead to binding commitments and binding regulations at the international level. The third aspect, which I think is also quite important to keep in mind, is to look beyond substantive IP laws. So we already talked about contracts, say the importance of contract for IP regulation in the online environment and specifically in the metaverse. But what counts ultimately, and that goes back to what you were saying, Helmut, earlier, in terms of trustworthy environment. If parties don't have trust in the way how dispute might be solved, even if you may give them very good rights at the substantive level, it's not going to work much. It's not going to help much. So it's very important to take into account in this ecosystem of IP regulation in the metaverse, the way how this can be solved. And in that respect, I definitely think that we should carefully include ADR mechanism, alternative dispute resolution mechanisms, and specifically arbitration. You have an example of a recent paper, which was published by two colleagues, also based in Geneva, by the way, who basically plead for the importance of looking at arbitration for solving metaverse-related disputes, and that would also apply to IP disputes. And the fourth and final point, and of course, that might be of specific relevance today, to see what Europe could do on that front, and what should be the role of Europe in the regulation of the metaverse, and specifically in the IP regulation of the metaverse. We of course know, and I guess we'll hear that in a few seconds and minutes, that the EU and Europe has been and is still at the forefront of many digital policy activities. You see that reflected in the book that you're on the screen, but that might also be, of course, an opportunity for ELI, and that was alluded to in the introduction to this session, what might be done in order also to make sure that European values and European principles are reflected in this global online ecosystem. And if we look at what's happening, of course, I have no time to look into that now, but there is a lot of action and attention focusing on what's happening on the other side of the Atlantic, specifically on that dispute, very high profile dispute, which is still pending. And of course, if you look at the way how people look at this dispute, you have the perception that it will basically govern the principle at a global level. It might be true, but at the same time, I think it would be important to look at it from a European perspective and try and see how we might, if need be, of course, come up with specific solutions from a European perspective. So this is basically what I wanted to share, and I thank you for your attention.
Thank you very much, Jacques de Vera, for these insightful comments and principles. And that leads us to the next stage already, data protection in the metaverse. It's my pleasure to greet Marit Hansen. She's a State Data Protection Commissioner of Land Schleswig-Holstein, sorry, and Chief of Unabhängiges Landeszentrum für Datenschutz. Data protection in the metaverse will be her topic. And before handing over, I just wanted to say that she's also a member of the Data Ethics Commission of the German government, which will probably be a link to what Helmut just mentioned. And she contributed to education and research on privacy enhancing technologies, and has awarded her an honorary doctorate from Karlstad University in Sweden. And with that, I think, Marit, I give you the floor.
Thank you very much, Pascal. Yes, I'm now talking about data protection law, but I'm a computer scientist. So I try to have both perspectives in my current work. And of course, this is quite often the case that we have to do that. And I also try to show you very few slides about the data protection law in the metaverse, which of course the data protection law is already there. Everybody knows the GDPR. So let's try to apply the GDPR. And here you see what is data protection? Why do we need that? In principle, it's about an imbalance of power, and therefore the need for the small people trying to see through the fog what is happening with data processing. It may be something that decisions are made about them, and they have no idea how to get informed. Data subject rights are difficult. And so we try to take the perspective of the individual, and not only because data protection sounds as if you have to protect the data and then it is everything done. No, it's about the rights and freedoms. But what we also see, the GDPR thinks not about, well, something very universal, but about controllers who decide on the purpose and means for data processing, and processors who are doing that, the processing on behalf of the controllers. This means there are obligations for those roles. There's no obligation if you're doing it as a private person. So if two people meet in the metaverse or in the street, then usually the data processing they are doing, like watching each other, perhaps handing over some telephone number, please call me for the next date or so. This is something which is in their private household activity, personal activity, and then the GDPR would not be applied. So this we have to have in mind, because in metaverse we've seen already many scenarios where kids were meeting others, perhaps where people can meet also in the business context, and then we will have to see who is the controller, who is the processor, and what about private people, and also, of course, some perhaps obligations. There may be other privacy obligations, and there may be, of course, other litigation issues. We will come to that in the civil courts, but this is not the GDPR issue. And so I only wanted to give you a small glimpse what is already there in the GDPR. Let's have a look into Article 5. There are so many data protection principles about the lawfulness. You have to have a legal basis, fairness, that everything has to be legitimate, transparency, those whose data are being processed have to be able to understand what is happening, which is of course a challenge in our world with artificial intelligence, augmented reality, virtual reality, not being able to, meanwhile, to distinguish the truth from disinformation, misinformation. Okay, but these are general challenges that at least the general data protection regulation demands that the controller informs about the data processing. We are always talking here about personal data. Not everything we will see in the metaverse is considered personal data, but at least it addresses very often human beings. So not the bots meeting other bots, that may be a bit boring, but real people and disclosing data, getting information, meeting each other, exchanging something. So we will see. The purpose, this is something which is not known by many computer scientists, for example, that the purpose plays such a big role in data protection law, because it depends on the situation, what is necessary to process the data, how long they can be stored, what can happen, and whether you are able to reuse those data for perhaps other purposes. The data minimization principles does not mean that you have to delete everything immediately, but again, depending on the purpose, what is necessary. Accuracy, of course, we don't want wrong information, but the granularity level is sometimes very, very difficult to achieve. Storage limitation, how long do you keep the data? They have to be gone after some time, but how long do you have to keep them, especially if there's, for example, some legal business, like contracts, like receipts, the bills, perhaps the tax law applies, and then, of course, there are also storage retention periods you have to apply here. And the data security field is also tackled. So what do we have to focus now where's our focus here? There are so many challenges, but they are to be differently solved according to the situation. For example, is it a real person or not? If it's not a real person, it's not personal data. Are there real names? Are there pseudonyms? Do people identify themselves? Do they have to identify, especially if they want to deal in a trustworthy area? Very often it's considered unnecessary for many people to interact, to know something, they are credit worthy, or I can charge them afterwards if something happens. I can, if there's a criminal activity, I can ask the police to accompany me in the metaverse, something like that. To be also aware of the situation, the transparency principle I mentioned already, is also not so easy, because as in the metaverse, you can play a tree, standing there, listening into everything, but nobody perhaps notices whether you're a real person or not. So this may be also a way of, eavesdropping. Then it's not everything is sensitive data, not everything is biometrics data, but it's interesting that by definition, if we have the glasses, they have to see, or the technology needs to know where you're looking at. This is a basic thing in the metaverse, because otherwise the focus cannot be adapted of this, what you can see with the glasses, to what you are really seeing. It's not possible right now, and it does not make sense to have everything in the real sharp and high resolution image. So where do you look? And of course also whether you look somewhere. We saw 4 bags in the IP talk. Which bag you looked at first? This may be the thing you're most interested in. This may be the thing you can be, asked for, whether you want to buy it. And there are so many involuntary reactions. If we have our mouse, we know where to click, and this is some really clear, different, defined action. I do it voluntary. But with the metaverse and the augmented glass enhancements, there will be more involuntary reactions. If we have a data suit for everything, even more. They may be revealing interests, emotions, like the facial expressions, perhaps health issues. And it may be also be good to be at a doctor's in the metaverse for some health issues. Why not? But still, it's another scenario. There are sensitive data in these cases. We have to take care of them. Okay, I now said it's necessary to have some information where the focus of your eyes is. But is it only for technical purposes? Are they deleted, those data, immediately after you take up your glasses or go into the next room? Are they gone, or are they used for advertising purposes? Or think of other scenarios. Your employer thinks, let's meet in the metaverse. And if you're not showing the right way of awareness or reaction, how quick you react on something you see there, working on something, then you may be in the lower 10% which get fired. So this is not a theory. This is being discussed for many issues. also in the school situation, I think it's a very good thing to learn in so many channels are possible where people perhaps can be better a better learner than in the current situation. Still, if somebody, it could be the teachers, it could be the school, the parents, it could also be those providers who offer that, if they could collect the data on the pupils, then we have to make sure it's a legitimate purpose, there's a legal basis, they are informed, it's a fair treatment, and not manipulation, which we've seen in the social networks has happened. So it's not a theory, it has happened, it will happen, and therefore we have to regulate or make sure, because data protection is regulated, that still the principles apply. And my two last points here, Metaverse will be an infrastructure, and therefore it's not one Metaverse, there will be several, perhaps some are more or less specialized on specific situations, something for example, for hospitals, for schools could be specialized, it could be for nations, but infrastructural things, I think, should not rely on being paid by personal data. So again, something where I expect the government to take some role, not in surveilling all the citizens, but taking some role, making sure that it's a fair thing, that you can also not be expelled from the metaverse if this is your workplace, that there have to be more guarantees. Interconnectivity, it should be so easy that there are gateways, but still we may have even for our old phones here, we can phone each other without having to know whether you're with Orange or Vodafone or Telecom, does not matter. Interconnectivity in social networks has not happened yet. In the European Commission, we see now for Messenger that the interconnectivity will probably happen, I hope in a good way. But still, if the metaverse is again only some gated community, some bubbles, then there may be more problems. So my plea is here that we have a diligent analysis of responsibility and legal basis for each scenario, because sometimes GDPR applies, sometimes not. If it applies, there may be different controllers, different processes. There are all the principles that have to adhere to. There are solutions. But we see also if we are not diligently applying the GDPR, then very often we see failures in adhering to the law, and often people get already used to that, providers will do that already, and changes later on may not be possible, or at least be very expensive. So thank you very much.
Thank you very much, Marit, for this very interesting these very interesting aspects. Indeed, we would need a whole evening just on these aspects, just on the IP. And here we have a whole line of panelists. So I will just continue now with Bernard Koch, because we mentioned contract, we mentioned, or we didn't, but we should mention tort law as well. And Bernard Koch is a professor at the University of Innsbruck and ELI council member. He's currently the Dean of Studies of the Innsbruck Law Faculty, but above all, he's a member of the European Group on Tort Law and of the former EU Expert Group on Liability for New Technologies, and serves also as the director of the university, academic director of the University of Innsbruck Medical Law Program, where, of course, many of these aspects, as has been shown by Cecilia Alvarez initially, may also be reflected. So I'm very happy to give the floor to Bernard. Bernard, you have the floor.
Thank you very much, Pascal, for this kind introduction. Welcome to you all. The first and foremost question when assessing potential claims in contract or in tort law necessarily has to be which law applies in the metaverse. Unlike in the real world, all encounters in the metaverse happen via contractual relations, since access thereto is provided by intermediaries with whom each and every participant has to conclude framework contracts and not just EULAs, as just mentioned earlier, that inter alia define at least ground rules for the online interactions. While people may still not know each other in advance, they are nevertheless bound by the same, at least basic rules of the game. Even if someone hacks into the system without the consent of the platform operators, that person is, or at least should be, aware of those ground rules. After all, they purposefully circumvent them. Since such intentional acts of wrongdoings are subject to special rules, however, I will ignore them for the remainder of my short intervention. Therefore, while delictual claims, apart from those against the hackers, may be possible, as in any other jurisdiction that does not include the non-cumul rule, a primary focus for adjudicating claims between ordinary actors in the metaverse will have to be on the framework contract granting access to it. The agreement will most likely, though not necessarily, include choice of law provisions, at least for matters arising out of the contract itself. This does not mean, though, that the interactions themselves will necessarily be governed by the same law, as those meeting in the metaverse can agree on a different law applicable to their transactions. But there's at least one joint element to be considered, in particular in situations where an escape clause may kick in when trying to identify the most closely connected jurisdiction. A judge may conclude that the law governing the metaverse platform or infrastructure may be more closely connected to the facts of the case than any other, in particular if the parties involved have no other joint connecting factor, such as a shared domicile, for example. Also, in tort cases, the framework contract with the metaverse operator may be deemed a relevant pre-existing relationship within the meaning of the Rome II regulation. However, since personality rights matters are excluded therefrom, that regulation may of course be less relevant in practice. Depending upon the layout and design of the metaverse platform, the actors may appear as avatars and virtually move around, as we've seen earlier today. However, while this may be visually enticing, it is of no relevance in law. Whether your activity is evident in the literal sense or not, there is a mere optical difference to interacting online via usernames in a purely text-based environment. The avatar either represents an actual person controlling it or is generated by some AI. Even the latter, however, is associated to some actual human or legal person to whom the AI activity is attributable. Therefore, while the metaverse may offer additional virtual space to interact and may provide a platform that overcomes the physical distance between real persons interacting, it is nevertheless the latter who literally play a role. Therefore, already existing case law on harm caused online applies correspondingly, even though one may not agree with it, of course. When it comes to transactions agreed upon in the metaverse, this is effectively like an interaction via Zoom. The only difference is that you may not see the actual live face of the other person in real time, but some character representing that person. The interaction as such, however, is the same from a legal perspective nevertheless. If you unleash an AI-driven avatar in the metaverse who may roam around and interact with other avatars and may thereby enter into agreements, whether or not this generates a legally binding contract for the person behind that avatar is a matter of agency laws and not some unsolvable mystery. Similarly, if your actions harm someone, the attribution of the cause can be determined by the rules of vicarious liability or some alternative theory such as liability for a source of potential harm. To conclude, the metaverse as promoted at present will provide a nice playground, and nice also in the sense of appealing, but does not seem to generate novel legal questions that cannot be resolved with the existing toolbox. Whether or not one is satisfied with the outcome of applying those traditional tools is another story, of course. Thank you.
Thank you very much, Bernard, for these insightful comments, and also for referring to this algorithmic contracting aspect. And of course, the ELI has a project on that, which is central and may play a role indeed on the metaverse as well, apart from all what you mentioned, private international law and other rules. Let's continue now with the NFTs and in the metaverse, because we have seen that a lot of things are sold and take value or lose value in the metaverse. And so we have asked Michel Canarsa. He is professor of private law and dean of the Faculty of Law at Lyon Catholic University to come because his areas of research are law and technology, international and European law and commercial law, as well as his recent books who focused on the interaction between law and technology, contract and product liability law. So we thought he, as a member also of the European Review of Private Law, might come with a specific insight here as NFTs in the metaverse. So Michel, you have the floor.
Thank you very much, Pascal. Thank you indeed. Thank you for the kind invitation. Thank you to the ELI for that. So yeah, in 5 minutes, just a few words on the NFTs, so the non-fungible tokens phenomenon that is, well, recent and even, and to a certain extent, quite old if we compare it to other new technologies. So so the concept of non-fungible tokens is quite easy if you want, because it's different from fungible tokens. So if you take the example of Bitcoins, Bitcoins are fungible tokens, so they are crypto assets, but they are fungible, so they can be exchanged. One Bitcoin can be exchanged against another Bitcoin. The concept of non-fungible tokens is that it cannot. So there is a unique piece or a limited number of these tokens. So the concept, as with the Bitcoins or Bitgold, is to create scarcity, to create a rare, a limited number of items so that you can give them a value and hope and expect that it will gain value in the future. One well-known example of an NFT, which you probably know, is of 2021. It was sold by auction at Christie's for $69 million. It's the title of the artwork is "Every Day is the First 5,000 Days" by Beeple. So you can easily find it on the internet, of course. So $69 million. So one can have easily the idea of the value that can be given to non-fungible tokens, to NFTs. What do NFTs and fungible tokens have in common? They are digital assets. So it's basically a piece of code, of computer code on a given blockchain. So quite often it's on Ethereum, but not blockchain, but not necessarily. So it's a piece of code. It has a unique value. There is, because it's on the blockchain, there is authenticity and ownership. So only one person can own a unique piece, a unique NFT, and can sell it to someone else. An NFT cannot be replicated. This is one of the major interests, and because of all these features, there can be a quite heavy valorization of NFTs. And they can be traded, they can be exchanged. And the connection with the metaverse and the metaverses in the plural is that if you want to make money on the metaverses, one good way to make it is NFTs, because well, you can exchange them on a given metaverse or between metaverses. Not only, of course, but mainly on the metaverses, and the blockchain is the underlying technical structure allowing it to function properly. So the game world is quite a good example, because probably the metaverse is in part heading towards the game world in terms of significant development. I've read recently that more than 3 billion people around the world, go to online gaming platforms. So it's a quite reasonable number. And there, for example, you can, buy items. So it can be clothes, shoes, weapons on certain platforms, or your avatar can be like embodied in an NFT, and you can transfer it to other metaverses, and to a certain extent you could sell it if you want. So there is a quite significant speculation, possibly at least, with NFTs, and the prices can be very high. This is why more and more regulators are looking at the phenomenon. So as you probably know, the European Union, well, just yesterday, by the way, formally approved, finally approved the MiCA regulation, so the regulation applicable to crypto assets, but it will not apply to NFTs. So probably the European Commission, the European legislator, is thinking of doing something as well in the field of NFTs in order to have a regulatory framework applying there, because as with other crypto assets, there can be legal issues, for example, infringement of IP rights, of course. This is probably the most common, but you can have money laundering, you have taxation issues, of course, and probably other legal challenges which are not easy to identify clearly at the moment. What is also true, and it was said before, is that the nature of these rights is not clearly defined at the moment, because they are not strictly property rights, in the sense that there will be, in any case, an underlying contract with the Metaverse platform where these NFTs are created and or traded. So the legal complexity is quite significant, and at the same time the market there is quite promising for various investors and various creators, artists, or individuals. So it's another quite exciting future to a certain extent, but without a clear regulatory or no regulatory framework at the moment. So I hope I didn't exceed too much my time. Thank you.
Thank you very much, Michel. No, the time is fine. And thank you for this insight on NFTs, which play an important role for the metaverse. You mentioned taxation, and we, of course, also thought of taxation. Some people suggested to tax robots. And then, of course, you want also, how does it work with the metaverse and taxation? That's why we asked Joanna Rizzi, tax advice manager by Deloitte Austria, to come and speak about taxation of digital assets in the metaverse. She has a strong focus on her work on the taxation of financial assets, including cryptocurrencies as well as real estate. And as a certified tax advisor since 2020, she is, of course, I wanted to say, at the top of these issues. She has also several academic publications and lectures in these areas. So it's my pleasure, really, to give you the floor, Joanna Rizzi, for a short aspects on taxation of digital assets in the metaverse.
Thank you very much. Thank you for the introduction. It's a pleasure to speak here tonight. And yeah, we'll try to give you some brief insights on the taxation of digital assets in the metaverse. So basically, I would say the metaverse brings new challenges and aspects also regarding taxes, because a lot is going on. Technology is developing very fast, and taxation kind of has to keep up with that, and is therefore also developing a lot. In recent years, a lot has happened in that connection. So yeah, basically, metaverse is a digital room for selling, buying, and storing virtual assets, and the acquisition of assets in the metaverse is usually done through NFTs. So two very interesting questions are: how are acquisitions and sales in the metaverse taxed, and how are profits in connection with NFTs taxed? So in the previous talk, we have already heard which important role NFTs play in connection with the metaverse. And basically, the acquisition happens through buying and selling NFTs. Therefore, we take a brief look on the taxation. I don't want to go into too much detail on the definition of NFTs, since we've already heard a lot of that. But probably Two important topics in that connection are that NFTs do not fall under the definition of cryptocurrencies regarding to Austrian tax law, and therefore the taxation regime for cryptocurrencies in Austria is not applicable to NFTs, but there are separate taxation regimes in connection with NFTs. For Austrian tax purposes, NFTs are considered as other incorporeal and intangible assets, and therefore do not fall under the cryptocurrency definition. So probably the most common case is that existing NFTs are sold or bought. So the NFTs can be bought with the cryptocurrency of the respective blockchain the NFT is represented on. Therefore, the acquisition of existing NFTs constitutes an exchange from a cryptocurrency into an NFT, so into an incorporeal asset. And tax-wise, every exchange of assets is a taxable event according to Austrian tax law. So what happens? You give a cryptocurrency and you receive an NFT. So you have an exchange. And what happens on the buyer side? So the buyer actually has to tax the increase of the value of the cryptocurrency. So the difference of the fair value at the time of the exchange and the acquisition cost of that cryptocurrency. So that difference is a realized capital gain at the time the exchange happens. So at the time this person buys the NFT, and is basically taxable in Austria. So if you have so-called new assets, these are cryptocurrencies that have been acquired after 28th of February 2021. This capital gain, so this difference in the value, is taxed with a special tax rate of 27.5%. If you have so-called old assets, so this would be assets that have been acquired before 1st March of 2021, the capital gain would be tax-free, but possible losses could also not be offset with other profits. And this is applicable if the exchange happens within 1 year after the acquisition of the cryptocurrency. On the seller side, the seller who sells the NFT has taxable income from so-called speculative transactions if the NFTs are held as private assets. So that means the profits would be taxable with a progressive tax rate. Also, if the acquisition and the disposal take place within 1 year. Otherwise, profits in connection with the sale of NFTs would be tax-free in Austria. If the NFTs are business assets, this would be operating income that would be taxed with either 25% corporate income tax or the progressive income tax rate. So the two important points in that connection that has to be taken taken into account is that with every acquisition of an NFT, you also have a taxable sale of the cryptocurrency you pay with. So every acquisition also is a possible taxable event where you possibly have to pay taxes on. In connection with minting, so with the creation of NFTs, the creators will usually generate business income. There no special provisions are applicable, but the business income is taxed like normal other business income from other activities. And since the acquisition of NFTs leads to a taxation of cryptocurrencies, I also want to give a brief introduction on the taxation of cryptocurrencies in Austria. With the Eco-Social Tax Reform Act in 2022, the taxation of cryptocurrencies has been included into the financial asset income, and also a legal definition of cryptocurrencies has been included into the law. I printed the definition on the slide, but I will not go through it in detail. But as I already mentioned, NFTs do not fall under the definition of cryptocurrencies. So these provisions are not applicable for NFTs. Basically, the taxation of cryptocurrencies is affected the special tax rate of 27.5%. There is an option for taxation with a progressive tax rate, which usually is not taken, because 27.5 is usually better than the progressive tax rate in Austria. The new regulations that have been implemented with this tax act are in force since 1st March of 2022 and are basically applicable to cryptocurrencies that are acquired after 28th of February 2021. Prior bought assets, so-called old assets, are principally not subject to the new taxation regime. So in connection with cryptocurrencies, the taxable events are basically the current income, so income you would receive from lending or other current income, as well as income from capital gains. So that would be, for example, the disposal of cryptocurrencies or the exchange for other assets and services, as in the case when acquiring NFTs. Before that, basically, so the old tax regime that was in place before 1st March of 2022 would basically say that NFTs and cryptocurrencies are taxed in the same way. So according to the holding period, if it is less than 1 year, you pay taxes with a progressive income tax rate, and if the holding period is more than 1 year, the profits in that connection would be tax-free. So in Austria, actually, they implemented rules in connection with the cryptocurrency taxation, and they explicitly said that NFTs are not included, and therefore these other rules apply where you are taxed according to the holding period. So I hope this could provide you with a useful overview. Of course, there is a lot more to say about the taxation of cryptocurrencies and NFTs, but yeah, I tried to give a short and brief overview. So where the main topics are included. And of course, if you have any questions or would like to discuss some topics, I'm always happy to connect. I included my contact details here, and yeah, please don't hesitate to contact me if you have any questions or would like to discuss some topics on taxation.
Thank you very much. Thank you very much indeed. The issue of taxation, as we can see, might be quite tricky, especially if you exchange cryptocurrencies with NFTs, and there's a risk of double taxation in a way. And you express that very nicely. We get now to our last speaker, but last but not least, because it's Renate Nicolai, and she's Deputy Director General in the DG for Communication Networks, Content and Technologies, the so-called DG Connect. And from 2014 to 2022, she served as head of cabinet of Vera Jourova, now Vice President for Values and Transparency, and before Commissioner for Justice and Consumers. So Renate Nicolai has been working on matters as central as rule of law, media freedom, or disinformation, but also now on the interaction with these DG Connect issues, and so also potentially with the metaverse. That's why we thought at the end of this evening of discussion around metaverse and the law, it would be at most important and useful to have also the perspective of the European Commission, if I may say so. And so it's with a great pleasure that I hand over to you, Renate, for your perspective and your comments.
Thank you very much, Chair. Thanks for having me, and most interesting to listen to so many distinguished experts in their respective fields. I think the most useful kind of way for me to contribute is actually to help you to understand a little bit what we are working on at the moment in the European Commission, and also in in my respective kind of services, because we are going to issue before the summer break an initiative on virtual worlds. We are not talking about the metaverse. We have created a new term, which is the virtual worlds, but it's in plural and not singular, to pick up some of the kind of issues. It's comforting to see the many kind of aspects that have been raised, the already existing use cases, the importance of trustworthiness, the importance of openness, the general kind of treat that I see coming out of the discussion, that there isn't a need to immediately go and regulate big time, but really rather to kind of maybe observe, use the existing laws, whether it's data protection, whether it's kind of IP rights, whether it's kind of contract and tort law. But of course, there will be also issues. Where do we come from? We come from, and I kind of personally also negotiated the data protection reform in previous roles. We come from a situation in Europe where we are indeed very advanced when it comes to digital rulemaking or kind of regulating the digital transition, starting with the GDPR that we heard about, but now also in the last couple of years, the platform economy, bringing accountability, the Digital Services Act, the Digital Markets Act, we're working on an AI Act. We bring really transparency in a system that has so far been rather opaque and complex for consumers, but also created, I think, less choice for society than we want to have. So it's with this kind of background that we look at the potential of the virtual worlds. And we see that, from the user cases that we have seen, the 3D dimension, what we are kind of, projecting ourselves in with the initiative is really the kind of the Web 4.0, as Commissioner Breton sometimes says, where really seamlessly we will have, the blend of, the physical and the digital kind of worlds. And that creates, of course, huge challenges in terms of, having the technology, dealing with the massive kind of, level of flow of data in terms of high quality and low latency. So that creates challenges for future connectivity. But then, of course, also the broader societal issues about how do we going to go about, the acceptance of this, and how do we want to govern this? And it's really in this kind of context that you have to see our future initiative. One aspect that you might find interesting when working on the future initiative, we also did something that is a little bit of a leftover on the conference on the future of Europe. I don't know whether you are familiar with that, but we had this project. And, actually, as one of the follow-ups of this project, we agreed, President von der Leyen from the Commission agreed that we should, on major initiatives, actually continue to engage with citizens beforehand, before we actually make our policy choices. So the kind of virtual worlds initiative is one of these important initiatives. So we have actually created a citizens panel, randomly chosen citizens from all 27 member states. And we had 4 kind of, detailed sessions with them where they stayed together, for weekends. And it was interesting because they came up with interesting recommendations, which showed kind of maybe 2 important things. Rather openness, I would say, to embrace the possibilities of virtual worlds, because there is no doubt a huge growth potential, a huge potential in certain sectors. And this is acknowledged. We heard from the user cases, there is industry, there is kind of, education, there's a lot of kind of sectors. But also the second point that came clearly out of that, lack of trust at the moment. So really kind of, the need for them to be reassured that this is going in a way that respects our values, that kind of confirms, the approach that Europe has always been focusing on, to have a human-centric approach in the digital transition. This has influenced also our line of thinking on the future initiative. It will not be legislation. It will be really more an action plan. It will be a kind of an opening for a debate, and it will also be, you know, an offer to actually look at Europe as a great place to develop the virtual worlds. Because what do we need in the virtual worlds? We need the technology, but we also need the creativity, and we heard that also from some of the business kind of, you know, speakers in the call tonight. And I think we are actually in Europe quite well placed to kind of combine this and make as much as possible out of it. We are observing that there are sectors that there are already advanced user cases, digital twins in industrial production, as one example, but we also observe that there are sectors at the moment where there is still a lot of reluctance, whether it's health, whether it's education. I mean, there isn't massive user cases. There are little lighthouse projects, but not in the massive way that we would need it if we really want to untap the potential big time. And that's why we are having kind of, I would say, 4 key kind of, you know, areas that we want to cover with the initiative. The first is a very big focus on using the initiative for virtual worlds to empower people. So, you know, there has to be, and we heard it also from other speakers, we want to create trust in this, you know, technological developments and these possible kind of, you know, developments for all of us, for sectors, for citizens, for everybody. But we want to make sure that there are principles that we stand for that are building on EU values. And that, of course, includes principles such as data protection, protecting of the identity. So a couple of things that have been raised also tonight would be certainly referred to. We will also probably come with a practical toolbox for citizens that they can use to kind of find their way through these virtual worlds. So really practical and principle based. So that's empowering people is very important. The second point is equally important, because if we want to make Europe the place for the development of virtual worlds, then we need to create an ecosystem that supports that. And that means, because, you know, gaming industry was, for instance, mentioned. We have kind of certain hubs in parts of Europe, but, you know, there are hubs in Finland, there are hubs in Spain. But what we should really do is kind of creating an ecosystem of them connected, because then they can scale up and then they can be a meaningful, you know, player, maybe an even a very big player at some stage in the future. So that's one idea, to really create that kind of, you know, a joined up approach on creating the ecosystems across the union. And linked to that is the idea, but it's an initiative, it's not regulation, but it's the idea to work with member states on a real kind of sandbox regime for virtual worlds kind of startups, to really give a signal that, you know, Europe is the best place to develop these virtual worlds. And here we are looking at, you know, the ideas, it's maybe familiar for some of you, to come with a 28th regime for, you know, this particular startup kind of scene. And also that would have to look at taxation, that would have to look at, you know, what we can do to facilitate the emergence of startups in that area. The third part is technology. And here it's all our work that we are doing on edge computing, supercomputing, to really have the computing power, which will be so essential. And here it's really important for you to know that whereas a couple of years ago, I would say we were not in the Premier League when it comes to supercomputing, because of a huge effort also in really joined up projects across the union, with a lot of research money from the European Union involved. We are actually, you know, playing in the prime league of supercomputing, which will be key to facilitate to work with the virtual worlds. And that leads me to the point of governance, which is really important. And it was also coming out of some of the statements by others. What we need to avoid in this next, let's say, revolution in the disruptive, you know, digital transition we live through, is that we recreate the walled gardens that we had in, you know, previous kind of phases of this digital transition. And that's why open systems, interoperability are key. And that's where the European Union, and I heard that also in one of the previous
presentations. We are an actor in digital rulemaking. We want to be an actor in kind of creating the governance for these virtual worlds. That's very much the idea. When it comes to my final point, when it comes to the things that we heard also from other speakers, what are the areas where I see more work necessary also on our side to study further, whether regulatory kind of, answers might be required sooner rather than later. I would define two. The one is I see an area of IP rights that needs to be studied further. And the second is, and it has come out clearly, is the NFT issue. Whether NFT, if we really want to kind of facilitate the trading of it, but also have kind of sort of fair structures for the trading of it, probably there might be a need for us to look into that. But it will not yet be in this initiative that you will see coming out before the summer break. It will probably be something that will be a debate for the future commission, because we are coming to the end of our legislature, and at the end of next year we will have a next commission, and probably they will then carry on that work that we are preparing the ground for with the initiative. Thank you very much.
Thank you very much. Thank you very much, Renate Nicolai, for this. I wanted almost to say concluding remarks, because you were able to pick up on various aspects through this announcement, so to say, of this initiative on the virtual worlds. And underlying this idea of soft law on the one hand that was mentioned, the empowerment that is central, of course, and the fact that we should not lose our values. We worked a lot in the recent decades on giving more power to the consumers, in giving more rights, and it should not be just lost because one changes the realm and get into the Web 3.0, as you rightly mentioned, so that the ecosystem must call for, taking over what exists and adapt it, which, as you rightly mentioned, means a different type of understanding of governance in a more inclusive way, probably as well. So thank you very much for that. Also addressing some of the open issues where maybe the European Law Institute could also look into it. That was also a little bit the idea of this ELI's Members' Day, to look into further projects, to look into the future. And I think that tonight we really did that. We don't have time now to open a Q&A session, because it's we already run over the time we had allotted to that discussion. But in any case, I think that thanks to all of the panelists, we had the fortune to have a very different perspective, ideas around a more broader perspective of metaverse or virtual worlds. And I think with that, we complied with what we wanted to offer today, a panel of thoughts and reflections on the future of some of central aspects for the EU and for Europe in general, which is virtual worlds or metaverse. So I'd like, in the name of the European Law Institute, to first of all thank also the members of the ELI Secretary that spent a lot of time preparing for this roundtable, so to say. And then, of course, to thank all my colleagues and all the panelists here for these very thought-provoking ideas. And I look forward to many further discussions. Who knows, maybe next year we will discuss not only the initiative on the virtual worlds, but NFTs and further projects. At least, thank you very much. I would like to say, enjoy your evening with a lot of virtual dreams, maybe, and that's also a parallel world. And I look forward to meeting you all again very soon. So thank you very much and have a wonderful evening. Goodbye.